Peace, everyone. Welcome. We're live and direct. Today we present to you the exodus from the racial constructive paradigm to national free status. So we're gonna start off by analyzing the part of the Montepani versus the Commonwealth of Virginia case. The Montepani, Mattaponi tribe versus the Commonwealth of Virginia. It states the Virginia court also concluded that because the tribe has not been granted federal recognition and has not shown that it otherwise has obtained protective legislation from the federal government based on an acknowledged guardian warship relationship, we discern no basis for concluding that the treaty is federal law based on such a relationship.
Now, I asked Professor Abdullah to stop right there because there's something very important when someone is denaturalized. When someone's stealing your birthright, this is called birthright theft in language. See, I'm going here because Professor Abdullah is right. See, language is a way of stripping you of sovereignty and your birthright. And if a people cannot see that or contest or protest against that to straighten that out as a government body, then they lost their sovereignty. Here it say, on an acknowledgement, guardian warship relationship. Now let me explain what this means. The guardian warship relationship is not with the United States. So I want you to know this. The United States is usurping that status. They want to be like the crown, statutory crown. That is a status that belongs to the crowns. When the crowns decided that they could not beat the Moors in war, they decided a new plan in the universities, the colleges. After learning from the Moors and seeing how the Moors linguistics was able to create children languages, the Albions and the amalgamated Moors came up with a system to strip the Moors out of their territorial estates in a different part of the earth. How was this done? Through language. Yes, it was done through language. The Europeans, when they first started, excuse me, Professor, when it first started, is this good time here? Am I standing here is good? When it first started, it started with status, started legislative created creature, the European occupying crowns. Now this is how it started. It started with the esquires who was taught in the English colleges or language that define people through title and language. Racism. Abdullah broke that down. Professor Abdullah, he probably go over it again today. Now, conquest legal person. What this conquest legal person is? Negro. Yes, the word Negro was coined before Indian, and Indian was coined before Mexican. These are conquest legal persons. You see here, these are people that, what I just read, fall under the guardianship, wardship of the crown. They became British, French, Spanish, Portuguese, Spanish, French, British national subjects. Now, before this happened, let me bring this up. Before this happened, the Moors conquered their kinsmen in their own land. When the Moors conquered their kinsmen in their own land, the Moors didn't regard them as Negro, Indians, and Mexicans. They regard them as Moor subjects. See, nobody is looking back to the truth to validate what's going on. We got to look in the history of these old conventions and treaties and information that the European powers, when the Europe occupying crowns, including the Pope, when they send their esquires here to do business with the Moors. They had to find a way to conquer the Moors. They couldn't beat them in war. So you could clap your hands on that. The Moors are strong. So the only way to beat the Moors is go to the ones that was already occupied by their kinsmen in their own land. So the Moors conquered their brothers, sister tribes, put them in conquest, and then they became Moor subjects. So when the Spanish found a way to defeat the Moors, they used language. They used the word negro. That way, they didn't have to honor the Moors, the earlier generations that signed the treaty, civilizations. If people can't inherit the philosophy and knowledge, to know who they are, and be called Negroes, then they can be considered the people that signed these treaties. This is why when France went to the World Court against the United States, the word Negro, Indian, Mexican wasn't brought up. The word Moorish was brought up. Moorish, Moroccan. 1952 case, France versus the United States in the World Court, The Hague. The word Negro, Indian, and Mexican was not even said in the opinion of that case. So what we have here, we have a system set up of a cheat and feudalist system that's set up to steal the Moors' birthright, their estate, is prevent the Moors from claiming the inherent claim. It prevents the Moors from claiming their inheritance because the Moorish treaties and the covenants use the word Moor, Moroccan, Moorish. It doesn't use Negro, doesn't use Indian, doesn't use Mexico. These are conquest legal persons created through legislator as a legislative creature of the law by the European occupying crowns. These are conquest legal persons. Remember that. Negro, Indian, and Mexican. Now, why is a Negro a conquest legal person? Well, the French, that's a French word. That's taking a Moor out of his legal description, out of his cultural identity. And even though the Negro, through consequentity, is more consequentity, but the culture, political identity changed now. He's not being called what the previous generations that signed the treaty call himself. That's a birthright theft. That's killing your birthright. Indian, British subject, French subject, Spanish subject, Portuguese subject, Irish subject. Why? Because the language is not the language that's in the treaties. Our ancestors made it clear. Under 1744 Convention Treaty, Lancaster, the Moors came down to straighten out the matter. And in that convention of 1744, the Lancaster Treaty, it made clear that Indians are considered as a separate conquest legal person. The Five Nations is in the treaty as the Five Nations, what Professor Abdullah will read later on. And you will see, and Indian nations. What are you talking about? These are the conquest legal persons that signed treaties with England and allow England to call them Indians, not Moors. But the Moors came down, the elders, the lords, sent down the elders, the jurisconsultants, the deputies to clear up the matter. And the matter was that the people you call Indians as a conquest legal person first is a Moor that was conquered by his brother's tribe, the Moors, and that he's a Moor subject. So language, Mexican come next. Hear the word Mexican coined by the Spanish, the Spaniards. You see what's going on here? As long as you claim these conquest legal persons, you cannot be protected by the Moorish treaties. When you go to the embassy, the crown has something called the Aboriginal Affairs that deal with Indians. They have what you call a bureau that deal with Indians, also Moors. Negro, when it's used, is in the same category as the Indian. and the Mexican. Now the word Moors is supreme. It's supreme over all this. Why? Because when in 1952, when France made a claim that it had the most favored nation clause over the United States, that's a claim that the allodian title holders, blood pedigree, consanguinity people signed a treaty with them first. And that the United States sovereignty first had an obligation to the crowns. Now somebody said, well, I thought the Moors. No, it was the crowns. I'm gonna tell you why. They had a revoke against their parent, the crown, their mother. They wasn't a separate nation that's going to war against another nation. That was an in-house war, civil war. Therefore, they still had obligations, liabilities, and restrictions to the crown. Whatever treaty they made before they got permission, any treaty they entered into without getting permission from the crown, by law is de facto, by culture is de facto. Somebody said, well, they signed a treaty with the Moors back in 17-something, and they signed a treaty in 1778. The lnheritance gave them asylum and amnesty as a friend and acknowledged them as a government. De facto. They was de facto. This is why somebody said, why did they go back to the crown in 1783? I'm showing you why. They went back to the mother. They went back to their mother. Without the mother, you have no standing to even enter into a treaty. I looked at this. You want to be called the United States of North America. That means you want to use the colony names. That's a franchise. You're a corporation. You're not a country. Nations don't give out franchise to and create countries. To create corporations that have the same functions as if a government de jure. Yes. So we have to look at what's around us. Please look around us. Why is everyone else claiming an inherent claim to something of old? And we're not doing that. We have to be educated. We have to be educated because we're never educated because we was, and we control the school system. They would never stole our birthright through language. We were teaching the proper grammar, the proper etymology. Epistemology had one used knowledge that came in, and the linguists, professors would have did right by us because they would be of us. Moorish consanguinity with a culture, political identity. So you see, the problem is we have to come together collectively in our different providence of Morocco, Turtle Island, Atlantis, and iron out our differences among ourselves. And stop letting everyone use us as merchandise, as sureties, as products. We got to stop doing this. The only way it's going to stop when we get educated. I'm sorry, don't hurt no. If your feelings hurt, I'm sorry. We got to do this. We got to stop letting men and women come up with wrong concepts that are not getting us nowhere on an international level. I mean, we're not even acknowledging ourselves of an inherent right. Now let me go to inherit. You got status under inherent rights and claims. Come on now, let's get this. We got to do it. If we get educated, we can do this. You got biological, which is blood. You got culture, which is the law. Moorish consanguinity, cultural, political identity. Ask yourself a question. When we was born into this indoctrination and psychological psycho-education, not education, psycho brainwash. This is not education. That's a separation. Please, that's a separation. We have not been educated. What do you mean, Shem? We're not educated. Come on, Shem. Yes, we are. No, you're not. I can show you how. Before the turn of the century, the late 18th century, our mothers started going into the political state of origins. the mother start giving what you call through the constructed education system and her surroundings in her territory, she was under fear and coerced, under duress and threats, which made her, when she had a child, she had to look for protection. She didn't receive the protection of her country, so she had to turn to a political organization for allegiance, for protection. That's involuntary because it's not done through education. It's not your country where you decided freely, you were educated, and you know you're Moroccan, you're Moorish, and you got a right to this your land, and you just went over and said, no, I think I'll be over here. That's voluntary. That's through knowledge, education. Indoctrination, psychological coerce, social engineer is involuntary, and it's like holding a gun to a person's head. It's a weapon. I once say the school systems is the gun. The bullet is the language. The trigger pullers is the ones that's teaching it. It's a weapon. If you don't believe, look at us now. Anyone that don't have, say, well, I can't see that concept, then look at us now. While we're demonstrating to imply and express actions, doing things that we're doing, voting for them, going into the courts, filing documents to be argued out, to settle out disputes, while we call the police when it's a danger to our house. Why do we go to the DMC to get a license? Why do we do all this stuff when we got our house to be put out and call a fire engine? When something go wrong with our electricity, we got to go to the county. Why do we have to pay them for our own resources, our water? Don't sit here and say that this is voluntary. It is not. It's involuntary because you are doing this and depriving yourself of the biological, cultural, more consequently cultural, political identity. You're depriving yourself of your cultural rights you're supposed to claim. That's an inheritance right. Listen, you have to know what inherit mean. You just can't get up or go to school and say, well, I know what inherit mean. I went to college. I know what that means. But be honest, too, you do have a form to know what that means because your father, billionaire, you know how to sit in front of an attorney, a guardian of your estate. You know how to sit there like a ward minor and let him read the will. And you are making a claim on the wealth and the will based on the name. So don't tell me you got a form and not know what inheritance means because you know how to show up when that will is read. Look at that natural concept that's been going on every day in the United States or the corporate states of origin. Look at, you're claiming that inherit reward. Now claim your more consequentity and your cultural political identity. You get more out of that. Okay, Abdullah.
All right, all right. As we continue, Alliance to Save the Manapani, 621 SE second at 95. This conclusion, however, is based on faulty logic. So let me read from the beginning because it was away from this. The Virginia court also concluded that because the tribe has not been granted federal recognition and has not shown that it otherwise has obtained protective legislation from the federal government based on an acknowledged guardian ward relationship, we discern no basis for concluding that the treaty is federal law based on such a relationship. Alliance to Save the Manapani. This conclusion, however, is based on faulty logic. The Manapani's lack of formal recognition by the federal government is an issue separate and apart from whether its pre-revolutionary treaty must be enforced as a matter of federal law under the Supremacy Clause. The federal recognition process does not create distinct Indian tribal communities. Read this again. The federal recognition process does not create distinct Indian tribal communities. Rather, a tribe that has federal recognition has simply had its status as a separate political body confirmed and is entitled to various federal benefits as a result. See example, United States versus Wheeler, 4035 US 13, 313, 322, pages 322 to 323, 1978. Governmental powers of Indian tribes derive from inherent tribal sovereignty. Read this again. Governmental powers of Indian tribes derive from inherent tribal sovereignty, not delegation from federal government. U.S. United States versus Laura, Lara, 541 U.S. 1993, 199, year 2004. Same. Talton versus Mayors, Talton versus Mayors, Mayes, 163 U.S. 376, 385, 384, 1896. Quote, powers of local self-government enjoyed by the Cherokee Nation existed prior to the Constitution. Prior powers of local self-government enjoyed by the Cherokee Nation existed prior to the Constitution. Read it once more. One more again. Powers of local self-government enjoyed by the Cherokee Nation existed prior to the Constitution. They are not federal powers arising from and created by the Constitution of the United States.
Now, Professor, can I ask you, Professor? I want to ask you a question.
No, ask me the question.
Yes, Professor, I want to ask a question. But there are Moors out there teaching that we are, quote, the Constitution is co-equal with us. They are saying that the Constitution, what we relied on for, we co-equal. I mean, we're partial with them. We impartial with them. We agree, we agree together.
And that the Constitution is the supreme law of the land.
Yes, can you elaborate on this statement here and based on?
All right, so let's read it again and then let's go into it. Powers of local self-government enjoyed by the Cherokee Nation, meaning that sovereign power existed before the formation of the Constitution, before the formation of any of the United States, before 1778, before 1776, before 1775, 1740, 1774, 1774, the Continental Congress, First Continental Congress, 1775, Second Continental Congress, 1776, Declaration of Independence. In 1778, the treaty between France and the United States. Also, the treaty between the Lenape Moors and the United States. Prior to that, the sovereign power existed. They are not federal powers arising from and created by the Constitution of the United States. All right. $1774. I'll put the years first. 1776, 1778, right? 1781, 1787, 17 89, 1791. This is the first, well, I'm going to need more room. First Continental Congress. So we had the first Continental Congress, second Continental Congress, Declaration of Independence, Declaration of Independence. We have the treaty between United States and Lenape Moors. Yes, let me finish this here. 1781, the Articles of Confederation. This is what they learn in school. All right. 1787, the Constitutional Convention. Constitutional Convention. Uh, all right. Well, 17. What? Go over there. Go over there, Shem. Okay. All right. 1789. This is the United States Constitution. Constitution in force. All right. Then you have 1791 Bill of Rights. All right. This is what's taught in school. This is what's taught in school. This is what's pushed in school. All right. These dates are pushed in school. These dates and then teaching about the formation of the United States. This is where they begin. If you were taking a civics class or the formation of the United States, they'll use this as a guide, as a model. They don't talk about the Moors. They don't talk about the Moors. They don't talk about the 1763 Treaty of Paris or as major staying points between 1763 Paris between France and Great Britain. They talk a little bit about the 1783 Treaty of Paris between the United States and Great Britain, but that's not a point of emphasis. That's not a point of emphasis. What is a point of emphasis is the Declaration of Independence is a major point of emphasis. Every year, July 4th, which is actually the Egyptian New Year, every year, July 4th, they're actually celebrating the Egyptian New Year, but they push that, Declaration of Independence, July 4th, 1776. So this, as far as a major emphasis, this is number one. 1776 is number one. This is every year. Every year. They point to this as their foundation. 1776. Not the United States Constitution, the Declaration of Independence. They don't. There's no annual celebration on July 4th. Celebrating 1787 or 1789. Where people ding ding ding, firecrackers and everything. This is major. All right. So our minds are being molded, but they're yielding their molding hands. Our minds are being molded to look to them as the foundation. And there are Moors, those who know they're Moors, who push this. There's those who know they're Moors who push the United States Constitution as a foundation for Moors. Those who know they're Moors pushed the United States Constitution as a foundation for the protection of Moorish rights. Enforce the Constitution. Enforce the Constitution. Enforce the Constitution. There are Moors who push that as the end all, be all, the salvation of the Moors. The salvation of the Moors rests on Moors pushing with full force, full might, full energy, full everything, the United States Constitution as their found, as their liberation, their salvation, as their God. That's push. I'm not exaggerating. That is push. That is a misconcept. That is a misconcept. That misconcept leads the Moors away from Moorish treaties. France. Why did France use as their salvation? Why don't Moors use as their salvation Moorish treaties, but France used as her salvation? Yes, France used as her salvation to make the claim of the most favorable nation status. France used as her salvation, put her foot in the ground on Moorish treaties in the 1952 case between France and the United States. France made the claim, petitioned the Hague, the International Court of Justice, in 1950, and made the claim that she has the right to the most favorable nation status. France used as her salvation Moorish treaties. The three types of treaties that was used to adjudicate that case. The first type of treaty was the primary type of treaties, was the bilateral treaties between Morocco and European powers between 1631 to 1891. Morocco and France, Morocco and the Netherlands, Morocco and Denmark, Morocco and Sardinia, Morocco and Belgium, Morocco and England / Great Britain, Morocco and the United States. So the second type of treaties that was used, that France stuck her claim in for the most favorable nation status, and Morocco, was the 1880 Act to Protect Morocco and the 1906 Act of Algiers. The third type of treaties that France used to stick her claim for the most favorable nation status in Morocco was the Treaty of Fez in 1912. So why did France use Moorish treaties, but Moors don't use Moorish treaties? Hold on, something's wrong. France used Moorish treaties, but Moors don't use Moorish treaties. Moors use the United States Constitution as a claim of their salvation, but France used Moorish treaties as a claim of her salvation, or claim the most stable nation claim. There's something wrong with this picture. Please, someone talk to me. Someone talk to me. There's something wrong with this picture. What did Ricky Mercado say? Lucy. All right. So we have to look back. Let's be like France. Let's be like France. Let's be like France, as France stuck her claim in Moorish treaties. Let's do the same thing. And I'm directing this way because France did that. France was awarded. France won the case, and as a result of France winning the case, Eisenhower did not close down any Moorish courts. Eisenhower had no authority to close down any Moorish consular court. As a result of the United States losing that case in 1952 in the International Court of Justice, the United States Congress legislated, renounced through a legislative act the claims in Morocco. So Eisenhower enforced the legislative act. United States enforced the 1952 case that they lost through the legislative act. Eisenhower just simply, through an executive order, enforced a legislative act. Eisenhower did not close down. He had no authority, no power to close down any Moorish consular courts. We must set the record straight. All right. Any questions in the chat? She needs the mic.
Yeah, I think it's time for clearance. I think we need to slow it down and back it up once again. Unfortunately, our people has been in a continuous loop cycle of disinformation. So I think it's important to kind of slow things down. Now, one would contest that because there's a constitution, it makes it a trust. Can you go into that? It makes it a corporate trust, which means that the foreign occupiers are bound by an oath to, I don't know, I guess protect the liberties of the Moors. But if that was so, why is there's warring still going on against the Moors? And why do the Moors still have problems? Now you have to act, you must look at this. Let's look at this in context. Let's look at it as a hypothesis statement. And hopefully it can pop some people pineal gland to kind of look at another direction. If the United States corporation, well, let's just do a scientific hypothesis statement. If the United States corporation is a corporate trust on behalf of the Moors, why the Moorish flag is not being waved at the headquarters of where the corporate trust sit? Let's just do a hypothesis statement. That's one hypothesis statement we can look at. A second hypothesis statement we can look at.
No, hold on. No.
Let's talk. Yeah, let's.
I want to put what he said. The United States. I want to put the claim. They make the claim. What's the claim?
The claim is the Constitution is a corporate trust.
United States Constitution, corporate trust for whom?
I guess the Moors. If the Moors on here screaming, it's a trust for us.
That the United States is a corporate.
We just gonna make an assumption. If you're saying it's a corporate trust, I guess you feel you can stand on it.
Can you have them and be more specific? They're saying it's a corporate trust for whom?
Let's go back.
I mean, saying it's a corporate trust. That's because that like we can't. It's like how do we respond to that when we not?
Okay, here it is.
Yes, corporate
United States Constitution is the foundation for the indentured trust agreements of the colonizers.
How does that relate to the Moors? Like
that's why I said we're gonna have to slow this thing down.
Right. Let's he or she did not mention that how that relates to the Moors. Because that's the issue at hand. How does that relate to us? Because they remember they're responding to what I'm saying. They're listening to me and they're writing in the chat based on what I'm saying. So the comment was born out of reacting to what I said. But the person, the natural person, did not indicate how does the United States Constitution relate to the Moors. To say that it is a corporate trust
if any
indenture,
corporate trust does not abide by its own bylaws in the sea of commerce, that corporate trust will be sanctioned. There's too many that and if and whom is the party to that corporate trust.
that's
The hypothesis statements are not being analyzed in questions.
who are the beneficiaries.
Who are the beneficiaries? And if we are the beneficiaries, you wouldn't have to go through a nationality process.
But prove it though. If we were, or if we be the beneficiaries, prove that we are. It's too much of we. Let's stay on this because this is faulty logic. What is the evidence that the one who's making the claim can lay before us that the Moors are the beneficiaries of the United States Constitution? What is the evidence? We, as I said before on Friday on DJ's show, put the law books down. Put them down. Put the law books down. Set the law books to the side and study epistemology. I think they will get more out of setting the law books to the side. I'm being real. They would get more out of setting the law books to the side and study and to study epistemology, how one knows knowledge, and study the structure way of thinking. They would get more out of that because I see a lot of faulty logic. They're picking up a law book without epistemological thinking and lessons, without etymology and semantics and grammar. They walking into a law book and not having Vital and Grotius and those jurists. They studied language, philosophy, political philosophy. They didn't start with a law book. They didn't start studying, picking up law books. They studied grammar, philosophy, political philosophy, language, logic, and reasoning. But we start picking up a law book, that's where the error is. We're picking up a law book first and not picking up grammar and logic and rhetoric and epistemology. So our reasoning is off. I have to address this. This is 28 years of observation. 28 years of observation. Tamara?
Okay, now let's go back to the declaration that was made, the Declaration of their Independence. And let's look at the contrast of how it's 2 years later. 2 years later, they had to run to the sovereign of the land, the Lenape Nation, for a treaty. Now, if one pull that treaty up, the first paragraph, I mean, not even the first paragraph, I would say the first sentence, truly explains the treaty with the United States, well, with the Lenape Moors. It's called the Delaware Nation, but truly, I feel that that is. I've been trying to make an appointment to get the original of that, because the word Delaware is a connotation, and it's actually Delaware, DE that space LA space capital WARR. That is the surname of what was he, a regent?
A lord.
A lord. He was a lord.
Yeah, Lord
So it was
Delaware.
Delaware. That is
Yes.
the next. So when you see the word Delaware, that is just the changing of the what is called the
Oh
uh,
yeah, it's a
reconfiguration.
it's a linguistic methodology of sound shifts.
Right. So
The
Lord
move
Delaware, DE
they're removing letters.
yes.
All right, and apocryphe and syncope, when you're removing initial letters and beginning, in the case middle letters
Does that
would
even
be with
count for the
syncope.
space as well?
Be sync.
Does that count for the space in
Well,
between?
if letters are removed, remember they're moving from Delaware to Delaware, so There's a removing of letters.
So the empty space count as a character as well?
No, empty space. Just let's look at the letters, not the empty space.
Okay, so the original spelling is DE space LA space WA
DE space
LA
LA
space
space
capital D W
capital W
ARR.
ARR.
Okay, so
Yeah, there's
the treaty would read, however, the treaty would say Delaware
yeah, so
Nation, which is incorrect connotation. So that spelling of Delaware wasn't was not
all right, so
derived
here we go.
back in 1776.
Yeah, so that's a
So when you find the treaty, even look at the connotation of that until we can find the original one, because I'm quite sure it'll say the Lenape treaty, with the United States, or it may say the Americas. Who knows? So could you go into a little bit more between the conflict between the 1776 Declaration of Independence that was proclaimed
all right.
and the 1778 protection with the sovereignty of the land?
All right, so keep in mind that the 1770, you have esquires who are convening, who actually are subjects of the crown. That's what when they convene, at the time of their convening, what was their status? The jurist would ask this. Were they sovereigns? Were they of nobility? Were they of the privy council? Were there counts and dukes and earls and marquis, or prince or king? What were their status at the time of convening? See, the way they teach it in the school, they're teaching as if they were of a sovereign status, as if they were that of a noble, of a noble, or a marquis or a count. Remember, they're on foreign soil. They have at the time of their convening and signing the Declaration of Independence, they had no treaty with the sovereign of the land. They were still connected with an occupying sovereign. So they're on our land without a treaty. What gave them the authority to convene? To forget signing anything. What gave them the authority to convene on a foreign land, foreign soil, just to convene? To have any discussion. To have any discussion that we're going to form, the Declaration of Independence to govern ourselves. What gave them that authority? What would give Shem and me the authority to come to your house, to come to your house. And Shem and I are in your house. We open the door and come to your house. And Shem and I are discussing. Shem, we're going to be able to use the refrigerator. All right. All right. You be able to do this. All right. So we're going to, Shem and I are writing, constructing a Declaration of Independence in your house. In your house, we're constructing a Declaration of Independence on what we're going to do in your house, how we're going to govern ourselves, how we're going to interchange in your house. What gives Shem and me the authority to come to a house to discuss anything about how we're going to interchange in your house? We got to rise to be jurists. We're looking at how they're presenting it as if they have authority, as if they're sovereign, as they have some sovereign authority to convene, to discuss anything. I don't care what it is. The fact that what gave them the authority to convene in your house? We got to look at this like jurists. That's number one. If you don't start there with your analysis, it doesn't matter what you say after that. Doesn't matter what you say after that, because your foundation's off. Your analysis are off from the jump. So anything you say after that they signed it, who gives a what? Talk about their authority to convene in your house. Remember, they are their great, oh no, that's 1776. So their great grandfathers and mothers were what? English subjects. Their great grandfathers and mothers, English subjects. They're not English subjects? English subjects coming together to convene about what? On foreign soil? All right. Ben Franklin. Here we go. Ben Franklin did go to the sovereigns. Ben Franklin did go to the sovereigns. The Hadanasi. Ben Franklin was instructed in the 1740s and 50s by the Hadanasi Confederation. Oh, but this United States Constitution, you got the Haudenosaunee Constitution, which Ben Franklin went to the Haudenosaunee and was taught, received lessons. See, what they're doing is they are misrepresenting themselves as that they are the sovereigns and that they wrote this constitution, and this constitution of, and now this constitution is the supreme over the Haudenosaunee Constitution. This constitution is supreme over everything. It is the supreme law and power of the land. The indigenous, native, autochthonous people ain't challenging that. The indigenous, native, autochthonous people, those who know their Moors, are saying it is that. The indigenous, you have some of the indigenous, autochthonous, aboriginal, native people of the land are sanctioning that United States Constitution is the supreme law of the land. I'm challenging those indigenous, autochthonous, native, aboriginal Moors who make that claim. I'm challenging them. I'm not challenging Albions. I'm challenging those indigenous, autochthonous, aboriginal, native Moors who make the claim that the United States Constitution is the supreme law of the land. I'm challenging their claim. challenging their claim. All right, Tamara.
We got some really great comments going on in here. Got some really great comments. Some of the stuff, I just want to read this one because I thought that was interesting. Someone took the title to the lecture series, the conversation. Let's call them a conversation. How about that? How about we start doing that? Just call them a conversation. And but at some point, these conversations have to create some type of unity. We can't just everyone just can't keep going on all these different, because you got StreamYard or YouTube or Facebook and having your own little individual little cliques, but we're in the same fight. And it's like the same fight of pulling one another down. Let's get some clarity. Let's get some understanding before we put so much weight on the disconnect or what's disconnected here. Let's just, the first thing we should know, and that should be our mantra, is we're under occupation and usurpation. Can we all just agree on that?
No, let's stay on that. She made a good point. She's making great points, bro.
If we
She's
can
making great
agree
points.
on that, I think we can come together and iron out all the rest of the differences one to the another. But I thought this was an interesting one because you spoke about language, because the topic was the exodus from the racial construct to your national inheritance status. Now, the statement reads the exodus is to remove the U.S. corporation off the shores of Morocco. Now, that's cute. That's cute. That's cute because you have to remember we have a long standing treaty with them. Our ancestors provided for that corporate body to exist on these shores. Now, in order to be able to stand up and have a conversation with that corporate body, they're operating exactly how they should want. They are operating in their body politics. That is their body politics society. But what we're failing to realize is that we have not united collectively to erect the Moorish Imperial Restoration Divan for to have these conversations. I'm just saying, just for those conversations to even take place, we must first do that. We must first unite, and to be able to get to the, and then after we unite, then we go to the point of just cogence, restoring ourselves back to the body of nations, so we can sit at the table and have these conversations regarding a breach of this, a breach of that. These conversations can't be had individually. So if one thing that these conversations can be had on the individual basis with just one body politic usurping the entire sovereignty of all the other various Moorish body politics out there, that is out of the laws of international law. So that's not going to happen. But let's just start with the one thing let's just agree on one thing. We're on the usurpation and occupation. Let's agree on that we need unity. Let's stay there. And then we can deal with if there shall be a removal, because before a removal, there's some dues and tributes that is due. So let's not even look at that point, because we have to get our minds clear first about who we are and what we stand for and what we have to, put back into the mud. We have to put the tree roots back into the earth. No, we don't have to take the MSTO over. The MSTA is its own political body politic. Okay, They are bodies assembly of Moors that have come together through the oath and doctrine of Noble Drew Ali to propagate the faith of Mohammedanism. They have a right to do that, just as you have a right to assemble and join together in your various Moorish provincial body politic. Draft your constitution, your moral conduct, or what you were here for. Vote for your different positions within that provincial ecclesiastical zone that you are to uh, operate in. Have your seal, have your flag, deposit that into the nation as a notification of this is your provincial ecclesiastical body politics. All the various body politics can come together, because first we have to come together one to another. So it's not about taking out any other Moorish body politic. They can assemble in their own moral conduct, just as we all can assemble in our own moral conduct. That's how that can be done. So, we have to first get to the point of knowing that we're all one in the same boat that's been sinking for a long time, and just as some of us been putting our hands over the holes, that we don't take ourselves all the way out, because at this point nobody's taking us out but ourselves. No one is doing it to us but us. So I think we have to look at that. Let's look at, as Michael Jackson said, let's look at the man, humanity. Man is man and woman. Let's look at that man in the mirror. Let's look at ourselves first. What are we doing? We have to look at that. This is not an external problem. This is our problem. Just like our same ancestors got in the bed, they turned their back on their own nations and jumped in the bed with the foreign occupiers. They did it then, they doing it now. We got some that's the gatekeepers of oppression, because they don't know who they are. They don't know their culture, their consanguinity. And even the ones who halfway think they know it, don't know it. And the ones who do know it, they hide it from the from the other ones in its purity. There's a lot going on. We have a lot going on in house. We have a lot of cleaning up to do. So, these conversations is so we can all speak to one. This is about our only time to speak to one another. This is about our only time to speak to one another. But then it becomes oh, this person know this, or this person don't know this, or this person know that, or this person don't know that. It's starting to be just a little bit too much, and little to no progress. And then you have the foreign, we sitting here worrying about what the foreign occupier is doing, and oh, you got to get an exemption and you got to get that. But if we were in our right and exact place, we would have people. Let's look at that. We would if that constitution is for our protection, where are the Moors in the government positions? Why aren't they sitting at the tables and saying, hey, this is the religious benefit, these are the religious morals of the Moors, and this is how we must now look at how the Moorish societies will operate based off this, whatever's going on. I'm not gonna say the word because we don't want the thing to get clipped. We know how they listening.
Oh yeah.
You got to remember, we have to come back to be signatories of the Berne Convention, so we can have our own wavelengths to be able to communicate without. So we have to look at that. So I'm gonna turn it back over to Brother Abdullah,
Shem.
and I do a pop Brother Shem. And so that was one of the things that we need to address with that is no, we're not letting dead weight distract. We're making things clear. In order to, when you see things that pop up in the queue, because these are just conversations. Like if I was in your house, Shem, or you're in my house and we having a conversation and you say something out of context, and I say something out of context, we should be able to have this fluid dialogue to be able to sharpen each other's sword mentally, right? And that's what we're doing today. We're not calling anyone out. We're not saying that someone don't know, they know less than Professor Abdullah or less than Shem or things of that nature. It's a conversation. And when we see something on here that needs some clarification or understanding, we'll speak to it. And if that person put more clarification in their statement and it jobs and makes sense, we all sharpen each other up and we keep it moving. So I'm gonna turn it back over to the brothers and hopefully we can continue to have this conversation and sharpening of the minds.
All right, go get to the next. Go to the
Yes.
next document.
This is one reason why you need woman energy, a woman.
Next document. That's already highlighted.
Oh, that's the Iroquois. You said Benjamin Franklin.
All right, the Iroquois Confederacy and Indian nations recognizing contributions to the United States. Whereas the original framers of the Constitution, including most notably George Washington and Benjamin Franklin, are known to have greatly admired the concepts of the Six Nations of the Iroquois Confederacy. Whereas the Confederation of the original 13 colonies into one republic was influenced by the political system developed by the Iroquois Confederacy, as were many of the democratic principles which were incorporated into the Constitution itself. And whereas, since the formation of the United States, the Congress has recognized the sovereign status of the Indian tribes and has, through the exercise of powers reserved to the federal government in the Commerce Clause of the United States, Article 1, Section 2, Clause 3, dealt with Indian tribes on a government to government basis and has, through the Treaty Clause, Section Article 2, Section 2, Clause 2, enter into 370 treaties with Indian tribal nations, whereas from the first treaty entered into with an Indian nation, the treaty with the Delaware Indians on September 17, 1778, the Congress has assumed a trust responsibility and obligation to Indian tribes and their members, whereas the trust responsibility calls for Congress to exercise the utmost good faith in dealing with Indians as provided for in the Northwest Ordinance. Let me stop there. Hold on. Let's stop there because I see some. Let's go back. Whereas from the first treaty entered into with an Indian nation, the treaty with the Delaware and the Indians on September 17, 1778, the Congress has assumed a trust responsibility and obligation to the Indian tribes and their members. Stop there. The language in the treaty doesn't read that. There's the treaty, that treaty, 1778, 17, September 1778. There's no language in the treaty that delegates the United States as trustees, gives them trustee responsibility. See? See, someone would have just read this. Yeah, see? No, go to the treaty. Don't go to this. This is constructive. I have to stop here. See, they're constructing. See, what have they with this language? They walked them right out of the treaty. The treaty doesn't read that. There's no clause in the treaty. In fact, in the treaty, there should be what? A deputy in Congress. Where's that at? Where's the deputy at in Congress? See? This is constructive. Shem, you want to add to this?
Yeah, thank you, Professor. I mean, hey, when you read a document, jurors can see this. Abdullah Bay see this, that, you know, first of all, you have two types of, when you say that the Lenape nation, they call it Delaware nation. The Delaware is a name given to them when they took away through language their Moor status. Lenape is a Moor. A Delaware is an Indian. That's why I said Delaware Indian. What is a Delaware Indian? Anyone that's been labeled, a Moor that's been labeled as a British or English subject of European crowns. This is why they use the word, they took out the word Moor and put the word Indian there. Why they put it there? They're still in the birthright. They're still in your inheritance. Now let me get to this other document. I say Abdullah read that. Let me get to the other document. Excuse me for a minute. Let me see. Where the other document at? Give me a few minutes. Let me get it. Hold on. It's not there. It's here. Okay. Let me see that. All right, here we go. Where's it at? I just had it. Hold on for a minute. I just had it. Let me find it. Give me a few minutes and I got it here. I think it's here. Where is it? Is it here? Here's the next document we're dealing with, the 1744 treaty called the Lancaster Treaty. And in this treaty, they're making a claim for about territory coming out of the ground. They're using the territory claim here. This is the Five Nation Moors, and this is the British, the English Crown sending forth our representatives dealing with territory dispute of land. Go, Professor.
All right. Brother, the governor of Maryland, when you mentioned the affair of the land yesterday, you went back to old times and told us you had been in possession of the province of Maryland above 100 years. But what is 100 years in comparison of length of time since our claim began? Since we came out of this ground, for we must tell you that long before 100 years, our ancestors came out of this very ground, claiming to be aboriginal, indigenous, autochthonous, autochthonous, autochthonous means, all right, autochthonous will go with this, from the earth, autochthonous, from the earth. So autochthonous is the proper word for their claim. They're making an autochthonous claim. Years are what? Since we came out of this ground, for we must tell you that long before 100 years, our ancestors came out of this very ground, and their children have remained here ever since. You came out of the ground in York in a country that beyond the seas, there you may have a just claim. But here, you must allow to be your elder brother and the lands to belong to us long before you knew anything of them. It is true that above 100 years ago, that came here in a ship and brought with them several goods such as owls, knives, hatchets, guns, and many other particulars which they gave us. And when they came and when they had taught us how to use their things, and we saw what sort of people they were, we were so well pleased with them that we tied their ship to the bushes on the shore, and afterwards, liking them still better the longer they stayed, they stayed with us, and thinking the bushes too slender, we removed the rope and tied it to the trees, and as the tree will liable be blown down by high winds and to decay of themselves, we from the affection we bore them gave again removed the rope and tied it to a strong and blank rock. Here the interpreter said, they mentioned the Osido count, and not content with this, for its further security, we removed the rope to the big mountain. Here the interpreter says they mean the Anandago country, and there we tied it very fast and rode wampum about it. And to make it still more secure, we stood upon the wampum and sat down upon it to defend it and to prevent any hurt coming to it, and did our best endeavors that it might remain uninjured forever. Doing all this, the newcomers, the Dutch, they acknowledge our rights to the land and us from time to time to grant them parts of our country and to enter into league and covenant with us and to become one people. This is important. We United States Constitution, the supreme law of the land. Moors are There's those who know the Moors are staking their destiny, their protection of their rights. Like, this is before this. This is 1744. And in this convention, they're making an autochthonous. When they say out of the earth, autochthonous is the proper word, not aboriginal, because aboriginal means descendants from the ancient inhabitants of the land. But autochthonous means from the earth. It's a more, a solid, they're making a tie to the earth, to the land. Yeah, joint claim. So the joint claim means joint, the word direct. Joint is French. Direct is Latin. So joint, coming from the Latin direct, the root word for direct is R-E-C-T, which is a form of R-I-G-H-T, right. Right means straight. Straight. How does right relate to the word straight? I'll tell you. In Hekapata, you're dealing with surveying land and marking boundaries. So right, R-I-G-H-T, is a surveying word. That's the original application, a surveying word. How does it tie to right today? It does. Here we go. Women, the matrilineal principles, where wealth titles, possessions, inherited claims, passing down inheritance and titles and kinship. It's passed down to the mother line. So we're talking about the boundaries, jurisdiction, and land boundaries and land markings. The word title, the etymology of word title, refers to mark, a marking. So title and right are related, and that in this etymology refers to boundary markings. See what etymology does? See what etymology does? So what they do with constructive language is remove you further and further away from the original intent. So what they're doing is constructing an artificial boundary for words, meaning that you can't have any reasoning, any discussions, any decisions, any opinions outside of this constructed boundary for right, for title. Then with surveying, possess land, tying to the woman. So they're making, so this is tied to autochthonous land. They're making a land claim. This is land claims. Status under inheritance, rights, and claims. Biological culture. All right. Biological culture. Biological. All right. Bio life. Bio life, the study of life. But if you're talking, now we're talking biological culture, we're talking the matrilineal principle. So biological culture is the matrilineal, ancient matrilineal system where the sovereignty, the original ancient concept of sovereignty is this matrilineal. Inheritance, this matrilineal system had been in place for thousands of years and was applied in function worldwide. This system of passing down inheritance, dowries, wealth, titles, and properties is preserved in the supreme law of the land. It's preserved in the supreme law of the land, the Nazi Constitution. This matrilineal, ancient, thousand-year-old system is preserved in the supreme law of the land, the Nazi Constitution, Article 44, the Article 47. That's the supreme law of the land. What's the problem, Abdullah? Those who know their Moors ain't been pushing that as the supreme law of the land. Nowhere in the United States Constitution is the preservation of an ancient system, matrilineal system. It's not there. The basis of sovereignty, original intent of sovereignty is this matrilineal principle. It's the sovereignty is based in the woman. In 1644 to 1648, 100 European powers met at Utrecht For 4 years, they ironed it out. You talk about wars, and they ironing out the differences. At Orridge, that is the Peace of Westphalia. The Peace of Westphalia, 1648, lays modern, not ancient, lays the modern concept of statehood and sovereignty. The ancient principle of sovereignty is placed in the woman. The matrilineal prince system that had been in place for thousands of years worldwide. You got to go back. We got to go back. They're stripping us. So as long as we are boxed into their constructive language, you'll never go back. We must learn to walk in the minds of our ancestors. We're not walking in the minds of our ancestors. Our minds have been constructed. We're puppets. And the constructionists are puppeteers. Oxford, the Philological Society of London, and S.H. Murray are puppeteers. Webster, Samuel Johnson, puppeteers, constructing and orchestrating how you think. Shem.
Man, boy, they're getting today. Boy, you can't come to finding this. Thank you. Thank you, Professor. Man. Woo. So I'm going to say this. Professor Abdullah summed it, and I'm going to point to this direction here. Conquest, legal person. That's it. Language. You've been conquered through language. Face it. The truth is out. There's a Moor professor teaching the truth, the proper principles and the right concepts. The only thing about it is we have to listen. We had Tamara say we have to lay down our certain moral differences that we have that's been created through the indoctrination, through the psychological, vicious, coerced doctrination that led us to have this condition in mind. Tamara, right, we have to lay that aside and just look back at what our ancestors have written on the record, testimonies, hieroglyphics, ruins, and then turn around and look at now how we ought to be conducting ourselves now based on that. That's our inheritance. So, man, I'm blown away what Professor Abdullah said and what Tamara said earlier. I mean, listen here. The bottom line is, this is a lot of love. Nobody here, like Tamara said, nobody here to embarrass anybody. Nobody here to pull one person. She made it clear about sovereignty, about government sovereignty. She made it clear about the right that the people have, the government sovereignty. She made that clear on both sides. She made it clear nobody trying to throw nobody down and nobody trying to take or rob anybody from anything. All we trying to do is get our people to love each other and come together and do what these people are doing around us, is looking back and setting up like our ancestors did, and we're not doing it. Really appreciate this. This is good. The documents, we read out of the documents, the Lancaster Treaty where Abdullah was reading, 1744, that was a convention. Later on in that convention treaty, you notice it's laid out like a adjudicated case. It's a convention. We will see how when they speak about Indian nation, That's not talking about the Iroquois 5 nations. They're the Moors. That's why in that convention it say the 5 nations and the Indian nation. See, when you put an and there, that's a separation. So they're dealing with status now of nations. One are conquest nations, and the other one are freeholds. They own. They mean they own the land. A talk. What you call it, Abdullah? Claim. A talk claim of the ground. They claim it consanguinity of the ground. That's a different claim. That's what we have to do. That ties you to a political, cultural identity. Once again, like Tamara say, we're not here to steal anything from anyone or to embarrass anyone. We're only here to clear up the misconceptions and principles that were said, statements that was made about the Moors being subjects of the crown and about the Moors needing a constitution to protect themselves. There's nothing written biblically old, looking back, that could submit that claim. There's no proof of that. I'm a firm believer. I go to the language of the document and read it. When it doesn't even say American. It doesn't say nothing about American in the Constitution. So where they get off saying the Americans? See, we have to read. See, when something is being drafted, the characteristics, the identity of the party is placed in the instrument. You hear me? Read the Constitution. Read. Was up to the even in the Articles of Confederacy, even in the Delaware Treaty, they're not even called Americans. So we asking yourself, even in all these different writings, Declaration of Independence doesn't even say American. Why are you adding a word or a status to people that they didn't even call themselves when they wrote their own Constitution? But you're here to say, Joe Biden said on TV, well, we here in America. Now, America, the Constitution doesn't say the American Constitution. It says United States Constitution of America. United States is of the political jurisdiction of the crowns. They're not the Americas. They hold a franchise title doing business in Morocco, which America, the political jurisdiction, like Europe, is the political jurisdiction on the other side of the world, where America is the political jurisdiction over here. And the Pope is that majesty, Catholic majesty is the emperor in the Americas, the Pope. So let's love everybody. Let's love one another. Let's just come together and stop making like it's hard. Let's gather together. I said earlier on a Facebook Live, if I was trained in a church and taught in a church to be obedient to a seer, and if I do that when I die, I receive an inheritance in a foreign, visible, invisible dominion. I get a body and I get an inheritance. Now, hold up now. Yes. Now, hold on for a minute. If I could be taught that, now let me look at culture. Isn't it true that people have a right to their nature inheritance and culture? What about that right? Now here goes somebody say, well, we all one. Okay, if that's true then, if we was all one, when he wrote the Constitution, why didn't he say we all one? When he wrote the Constitution, why didn't he say Moors are supreme to us? It wasn't without the Moors, we wouldn't be here. Why did he write in the Constitution that we signed a treaty, we give them great things to Lenape Moors, and that they are separated and that they are over us, and that our sovereignty came from Lenape Moors? Why is that not in the Constitution? We all one. See that all this stuff got to stop. Every time you catch them lying and they're doing fraud, here come your statement. Oh, we all one. Why fight with each other? Well, somebody come in the house to rape your children and your wife. You ask them, why fight with one? You better defend your wife and children. That's your culture, right? Don't make that statement, say we all one. if we was all one, then why didn't they put in that Constitution, or why didn't they write in their documents that you was here before them and that they got to derive their authority from you? Why that's not written in there? Why it's not written in that they're Americans or any Moors written in there? Not even the Indians are part of that society. Then why, when it's not written in there, why you let them say it and you go for that? Why you become a part of that? Then you say, well, we ain't got no weapons to fight them. Yes, you do. You got weapons to fight them. You got your conscience, your divinity. You got your right mind. When you get back in your right mind, when you can talk right and listen, you can free yourself. You can free your people when they like that. Well, Abdullah, you want to talk about the class? You want to talk to you? Okay. Once again, we see all this go on around us. And you know why we accept it? It's not because it's voluntary. It's a condition put on us. In that condition, it puts a condition of fear. When the nations came together and signed the Refugee Convention Treaty, that statement of well-rounded fear is in it. And it talks about religion, education. See, you're afraid. People are afraid to be educated. People are afraid to band together and say who they are and claim their culture and their land as a people. Where do that fright come from? First thing is they indoctrinate you so bad and social engineer that you're afraid that your sister, your mother, or your brother, or your aunt, or your uncle gonna turn against you. When the people is in that kind of mind frame, they can never rise up again unless they be educated and know why they've been put in that kind of condition. Now, somebody say, well, I don't agree with that. I can prove a false story called Roots. Roots was made up to root you in the earlier generations that came before us of the old age, to root out of them their knowledge of being a part of the land, of the people that sent or ancient ancestors as this land. So when they came up with that story, they was able to place it in the school, like Abdullah said, through language. So they made what you call a puppet, what we call a status legislative creature, created creature, to conquest legal person. So they created this. They turned around and said the Negro, but they didn't say the Indian. They didn't say the Mexico. They left the Latino out. They left the Puerto Rican out. But they had to get one person sunk into this, the Moor. Why? Because the Moor is the only one that can make a allodian title claim to the land. You got to indoctrinate that Moor. We want about the Indian, the Mexican, the Latino, the Puerto Rican. We ain't worrying about them because all the nations down in South America called the Latino nations. Latino, that's conquest. That's a conquest legal person. But when you hear the word Moor, like Professor Abdullah said, it is used as a foundation where France stepped his feet and say, this is my foundation, I ain't gonna move. France made a foundation on Moor. Why did France use the Moor as a foundation to stick his feet and look and say, I got ground to stand on? Because that's the ones that have the right to the allodian titles of the land. And here we is, and we got to admit it, it's too fair. It's involuntary because it comes to a indoctrination school system. And it comes to what you see every day, that not only do the foreigners leech out you, but your own people. They get paid. They made their life getting paid fortunes, being involved in these Ivy League arenas that's making plenty of money, where they ruled out the Matrilineal principle of honoring a woman and then honoring a structured household. So they take that and throw that in a garbage can among us and look at a movie star, a sports basketball player, a football player, a hockey player, a soccer player, a volleyball player, a director to write fiction and promote fiction, a college professor that teaches linguistics apartheid, constructive language, Honor them. We taught to honor them, but not honor our Moorish consanguinity, cultural, political identity, and the matriarchal principle, which we come from the biological culture. See, we're not taught to honor that. Because, you know why? Because you can make an inherent claim. See, there's an inherent claim that's given to you. It's a culture right. It's a divine right. They don't want you to have that. So they said, we got one other place to go at, into the spiritual divine institution, nations, and take them out of nationhood and bring them over here into conquest legal person. Somebody said, how are they doing that? I'm gonna ask you a question. Show me one church, a priest, a pastor, a bishop, or elder make a claim and say, I want the whole world to know that we stand as a nation under divinity, and we stand under culture as a Moor, and that we have the right that was given to us by our seer to have government, principalities, and administrations. Why are none of them teaching that? They've been psychological coerced. They've been raped. Excuse me for saying they've been raped. So what we get is a damaged party up there with a Bible, up there with a Quran, and not even teaching the true concepts out of them books. And remember, them books tie back to culture. Yes, they do. What do you mean, Shem? The Mennonites, the Amish, the Mormons are claiming to be sovereign nations under seers and don't want nothing to do with the state or United States or any system that's outside the what? Because remember, they teach the matriarch system too there too. The women teach. That's why they got their own schools. Go into school, you see teaching, majority women. I dealt with them, I know. The women have the children. The women show the children stuff, teach them in the house, teaching them, train them, tutor them. What is the woman doing? She handed down the principles. Yes, she is the elder in her house. She's teaching. What's going on here? We get in the house, we marry a woman. You don't understand what that means. I rule my house. You don't even know what that means. If you don't honor something of principles laid down biblically to culture, you're not ruling your house. That's what ruling your house means. Be obedient to the culture and what the seer said. So, Tamara, you have anything you want to say, Tamara? Well, I'm glad to be here. I'm glad to be in a number. I love all of y'all. That's why me, Tamara, Abdullah, and other of us take our time to make sure we put curriculums together. We put things together so we can educate you. We don't want to control your mind. We just want you to look back to the true principles so you can validate and verify everything when you listen to it or you read it by seeing it. It's the only way you're going to take in anything is through listening and seeing. If you lose your eyesight, the hearing picks up for the eyesight. If you lose your hearing, your eyes can pick up what it can read. Now, God forbid, if you lose your eyesight and your hearing and your mouth just can talk, that don't mean nothing. So the Moors are in a condition what I see of the three monkeys. One got his hand over his mouth. The other one got his hands over his eyes. The other one got his hands on his ear. That means they can't speak, see, or hear. Three animals sitting there. One got his hands over his mouth. The other one got his hands on his ear. The other one hands on his eyes. What that mean? That mean can't speak, can't see, and can't hear. And a party that's in that condition mentally is in bad shape. When you can't speak, you can't hear, and you can't see. Go back and look at the three monkeys. We don't want to be like that. Thank you very much. Give it back over to Professor Abdullah. Okay.
All right. Peace, everyone. The Academy of Providence is our upcoming class in 2 weeks, September 25th. Public Administration and International Law. We'll spend about last 10 minutes talking about the course, upcoming course. I'm going to read the about our program. The 12-week contract law course will teach students governmental procedures dealing with diplomacy and international law. Secondly, students will be taught how justices and jurists weigh in on the facts and merits pertaining to treaties, acts, covenants, conventions, constitutions, and agreements affecting nations whenever they are disputes based on agreements or contracts signed between two or more nations. Finally, students will learn the principles, procedures, and remedies pursuant to international law and adjudication collateral estoppel. Enroll now. Go to UnitedRepublicOfMorocco.com and click on Academy of Providence. The course is a 12-week course. It'll be a course be on Saturdays from 12 p.m. to 4 p.m. Eastern Standard Time. Because the classes are recorded, you have an opportunity, should you have to work, to watch the class the next day or any time during the course of the week. Yours truly, Shem Malachi Bey and Abdullah Mosi Bey are the instructors for the course. Shem, you want to talk about the class?
Yes. One of the things we didn't talk about during the Facebook Live we promoting the class was red judicata, collateral estoppel. Anytime the world court make a decision dealing with, in Morocco and what they call North America, Central America, dealing with territorial rights, treaty rights, no state or the United States has a right or the authority or the power to bring that case back up and relitigate it all over again in their courtroom. You hear me? They are collateral estoppel, red judicata. You cannot litigate something that's already final by a high tribunal. You are collaterally stopped from, you are collaterally estoppel from bringing any claim that arise that already been settled with that dispute. Now, we had a dispute about land in Morocco. The Gantt Treaty dealt with land, territory guaranteed to the Moors and Indians. Administratively, we have to learn to come together and form a community in order to force that royal decision. Remember, the attorneys, the esquires, are not trained to know this, but the American Bar Association deal with jurists because they deal with international law. A jurist know this, that when a principal most favored nation sue a subsidiary or a grantee that was granted a letter of patent, the crown brings his claim into the world court because the letter of patents now has a corporation, an industry that's doing business in the land patent territory, in the patent territory, jurisdictional patent territory. Once that case is decided, no state, bar association, attorney general, community, or people, actives, organizations, international foundations can ever bring that matter back up as a collateral attack. You'll stop. You'll stop, or you can't mean you prohibit from doing it. When something like that happens, you need a government to file a writ of prohibition. Prohibiting, blocking that, barring that. See, when you don't have a government, you can't do that. I'm going to run to the United States. United States doesn't have jurisdiction to hear that. Because the United States was litigating in a world court, tribunal, and they lost. So the United States don't have jurisdiction. The courts don't have, but this what happens. when you don't know law, culture, you don't know rights of treaties and agreements, and you're not considered as a people under Moorish consanguinity and political cultural identity. And as a Moorish government, they can go into the courts, and they got power to speak, because to them you are under a guardian warship. Abdullah read it. Guardian warship. Come on now. A war going through the guardian saying, hey, I got problems. That's how they know they got you. When you claim to be a Moor and you walk in that courtroom and talk about they don't pay you no mind, man, they don't care about what you do. They're supposed to. They ain't got authority. They don't have authority. The Moorish nations did not delegate them authority to rule and decide over Moorish affairs and land and disputes. The Moors say the Moorish council had that right. Or the indigenous Moors say the deputies have that right. So what are you doing there? Well, Indians, that's connotative too, because the Indian is a British national. The 1926 World Decision, when the Great Britain took the United States to the World Court on the Gantt Treaty that's dealing with land rights, United States lost and New York lost. What came out in that case was called the freeholders through letters of patent. So the status of an Indian came out. He's a British national, a British subject. Therefore, Indian national. An Indian should not be even though United States Constitution say, but that's against the treaty, against the world decision. When they went to the world decision, that nullified that article in the Constitution now. It does not give the United States the right, even if they sign up under the Bureau of Indian Affairs, when they got a legal matter, they got to go to the British Council. That's the world case say. When a state try to bring up, or United States try to say, no, they're part of Indian Bureau, you can say, well, you lost in a world court on the status of the Indian. It didn't say you have jurisdiction over the Indians. On the Gantt Treaty, you would have won. You lost. So we have to use these world court decisions to stop them as rat judicata, collateral estoppel. We have to stop them. Anything you want to add, Professor Abdullah?
I'm writing on the board. I'm writing on the board that the Indian is a British national in international law. An Indian is a British national in international law pursuant to the 1926 case between United States and Great Britain. Great Britain on behalf of the Cayuga, all right, Cayuga tribe, and they based on the Gantt Treaty, between United States and Great Britain, 1814. All right, so these are key. All right, so we want to thank you again, everyone. Trust to see you in house in 2 weeks. It'll be 15 days from today. That's September 25th at 12 p.m. Eastern Standard Time. That's public administration and international law. Go to unitedrepublicofmorocco.com and click on Academy of Providence. We offer 2 payment options, a payment option of full and 2 partial payments. We are extending the second partial payment. Should you choose the 2 partial payment options, you pay the first partial payment of $150. You would have, by the September 25th, you would have an additional 2 weeks after the class begins to pay the second partial payment. Once again, go to the unitedrepublicofmorocco.com and click on Academy of Providence. We thank you again for your comments, your criticisms, your thoughts, your interaction, your attention. Thank you for viewing. We trust that we have illuminated you and that we have stimulated great discussion, great mind illumination, all right, and enlightenment. All right, we see you again. We'll see you, we see you on September 25th here in the house or on the house via Zoom communication. All right, as I said before, the classes are recorded. Should you not be able to take the class live, you can take it at your convenience during the course of the week. Thank you again. Assalamu alaikum. Veda Makum. Islam. Peace, everyone.